Hello and welcome to Wills for Heroes volunteer training. My name is Alex Rogers and I am the Director of Programs for the North Carolina Bar Foundation. Wills for Heroes is a program of the North Carolina Bar Foundation. The North Carolina Bar Foundation is the charitable arm of the North Carolina Bar Association and exemplifies the legal profession's commitment to service. Through foundation, pro bono, and civic education programs and our endowment, we unite the talent and the generosity of our profession to be a power of greater good for the people of North Carolina. Our foundation's programs and endowment funding priorities are all guided by the foundation's values, which are access to justice, service through the profession, civic education, professionalism, and diversity, equity, and inclusion. These values define for us what it means to use our skills, our means, and all of our professional resources to serve North Carolina communities statewide. The foundation lives out its mission and values by creating opportunities for lawyers, paralegals, and law students to serve. How the virtual Wills for Heroes clinic will work and provide an overview of the documents offered through this clinic: the last will and testament, healthcare power of attorney, advance directive, and durable power of attorney. Finally, we will walk through the app designed to guide you through the client interview and generate documents. The Wills for Heroes app. So we will be using our Wills for Heroes app to conduct client interviews and generate the client's documents. The app walks you through each document, providing fields for you to type in or select information provided by the client. The app then generates Word versions of the documents, which you would download for review. The app saves the documents, and you can edit the documents within the app. After we review the substantive piece of the training, we will walk through the app. Malpractice coverage for volunteers. So the North Carolina Bar Foundation provides malpractice insurance coverage for your service as a volunteer in the Wills for Heroes clinics. The documents we use in the clinic are form documents. Our malpractice coverage requires us to remain within the terms of the forms and not redraft to meet any unique client needs. In the event that a client has wants or needs outside of the scope of the clinic and the forms provided, please direct them to the North Carolina Bar Association Lawyer Referral Service at 919-677-8574. I will now turn things over to Samantha Gordon, one of our lead volunteers, to review the 4 legal documents.
Hello, everybody. I am Samantha Gordon. I am an attorney in Charlotte, North Carolina, and I've been a lead volunteer with Wills for Heroes since 2018. So we're going to start off with going over the 4 legal documents we will be using today. We are going to be doing simple wills, healthcare power of attorneys, advance directive, and durable financial power of attorney. Clients can select to complete any or all of these documents. However, we would highly suggest clients complete all 4 documents to avoid timely and costly court-related procedures in the future. If you have a client that is unsure about completing all 4 of the documents, just please let us know and we will be here to assist you. If a client only has one person to name as an executor or an agent for their power of attorney, that's fine. A backup is important, but having all of the documents with at least one person named is even more important. So the next slide, the documents are what they are. So we have specifically drafted the way that the documents are to provide simple estate planning documents to first responders through this program. They should not be altered. Volunteers should not offer or suggest drafting the documents in any different manner than what has been provided. We do understand there are different ways to draft estate planning documents, but this program is not meant for complex planning or any alternative estate planning options. The documents are what they are. So the first document we're going to go over is the last will and testament. So document overview. A will is a legal document indicating a testator's directions for distributing assets after their death. In the case that a testator has children or minor children, a will may also provide for the creation of a trust and or the appointment of a guardian. In this clinic, we only provide simple wills. So there are 5 versions to choose from in the app. Clients have been provided information to help them select which will applies best to their family structure or how they wish to distribute their assets. Still, it's important and potentially complicated decision. So clients may have questions about which option to select. It's essential that you get an accurate picture of who is involved, especially if there is a legal spouse, even if they are separated or estranged, because of special protections spouses receive under the law, which we'll explain more in some slides down the way. Individually, if you are working with a couple, you want both wills to mirror each other. So meaning you want the wills to have the same outcome. So the example is to each other, then to their kids. If the wills do not mirror each other, someone who was intended to be part of their will could be left out. We do not want to subject these wills to any type of litigation. Just keep in mind that these are simple documents. So I'm going to go through the options that you see on your screen right now. So option A, that's all to spouse. So this option is for a married couple who has adult kids. The language states everything goes to the spouse first. Then in the event the spouse has predeceased the testator, everything will pass the testator's issue. So meaning their child or children by blood or adoption. This option is also for married couples without children. If the couples do not have children, please leave the issue language and include that information in your email to us once the documents have populated. That way, the reviewing attorney can make the necessary changes to the wills. We do understand that some volunteers may practice estate planning, but we have estate planning volunteers who are specifically going to be reviewing the documents in the afternoon for these issues. If clients want to name an alternate beneficiary after the spouse, please let us know during the meeting so we can also discuss that with you. Option B is all to adult children, no spouse. This will is for a client who is single and has adult children. Everything passes to the adult children equally. We cannot change the distribution amounts. Assets will pass equally between all children. Option C is all to spouse and children in trust. I will discuss more about the trust options in upcoming slides, but basically this will is for a married couple who has a minor child or minor children. Keep in mind that option D, all to minor children in a trust, no spouse. This will is for a client who is not married and has a minor child or minor children. Keep in mind if the client is divorced, they should understand that if they have joint custody with the other parent, their parent will likely be appointed as a legal guardian of that child or children, but they can still name a guardian in the will as a suggestion to the court if that other parent is not available. Option E is all to named adult beneficiary or beneficiaries. This will is for a client who is not married and does not have children. Keep in mind these beneficiaries should be adults because we do want to avoid having any type of minor beneficiaries that are not children. So in the next slide, we're going to go over just some terms so everyone feels familiar. A testator is our client. That's the first responder, the person who's making the will. An executor is the person the client has selected to carry out the will. We suggest you recommend spouse's name other as their primary executor. They can then also name a successor executor or a backup. Trustees and guardians will only be named if the client has minor children. So please keep in mind, if you are dealing with a couple, that a spouse should not be named the trustee. The trustee will go into the trust, will go into effect if something has happened to both of the spouses. So you don't want to name a spouse as a trustee. A trustee should be a person the client trusts and thinks is responsible. A trustee is named if the children are under the age of 25 and the client chooses a will requiring a trust. A guardian is only named if the children are under the age of 18. Trustees and guardians do not have to be the same person, and many clients elect to make these different people. Couples must decide on the same guardian and trustee. In case it comes up with your clients, we do not recommend naming a corporate executor or trustee or trusted advisor for these simple wills. There are usually hoops to jump through, and financial advisors are not allowed to serve in those fiduciary roles. So then the next slide talks about revocation. The interview script asks right away if the client has ever had a will, a power of attorney, advance directive, or a healthcare power of attorney. If the client has a previously executed will, they will need to revoke it. In North Carolina, a will can be revoked by destroying the document with the intent and purpose of revoking it. The client should do this. If they have copies, they should make all attempts to destroy those as well. Although the will is revoked by destroying one properly executed copy with the intent to revoke, It's good practice to destroy all copies to avoid any complications in probate. The wills we are offering through the clinic will also revoke the previously executed will. So on this next slide, we're going to talk about key information to explain to the client. So as mentioned before, the clinic provides simple wills. The documents are what they are. The wills were simply drafted, specifically drafted the way that they were to provide wills to first responders, and they should not be altered. These wills are not intended for people who have complex estate planning needs. So for example, if their estate exceeds $11 million, if the client has a special needs child, or if the clients are a blended family. Wills for Heroes volunteer services are not recommended for clients who want to create multi-generational wills, for example, a distribution to an adult child and a grandchild at the same time. If any of these situations arise during your appointment, inform the client that you will not be able to provide a will through the clinic and offer to complete the other 2 documents. Now we have 3 because we have the Advance Directive. Advise the client to seek the guidance of an estate planning attorney for those specific needs. So we need to talk about spouses. In North Carolina, the spouse has an automatic right of election unless a prenup, postnup agreement, or the client has a separation agreement that waives their right to an elective share or the right to inherit. That means that no matter what the will says, barring the prenup exception, the spouse gets a chance through probate to claim a certain percentage of the estate, even if the client and spouse are separated or estranged. If they are still legally married, the spouse can claim this right. Divorce, however, voids any gift made to a spouse in a will. If the couple is remarried, the gift clause in the will is revived. If the client and spouse divorce and the client still wishes to make a gift to the spouse, the client will need a new will naming the ex-spouse specifically as an adult named beneficiary. Suffice to say, advise the client to seek a new will if divorce or other major life circumstances arises that would affect the terms of the will they're doing today. So on this next slide, as promised, we're going to be talking about trusts. So 2 of the wills offered provide for the creation of a trust and appointee of a trustee. Option C leaves all assets to a spouse, but if the spouse dies, the trust provision in the will creates a trust if there are children under the age of 25. Option D creates a trust for children under the age of 25 and does not provide for any gifts to the spouse. It's important to know the ages of your client's children because we need to make sure to select a trust option even if the child is not a legal minor. So if they're under the age of 25. The age is set to 25 at all of the documents. If a client asks why 25, you can explain that this is an age where a child will most likely make the most reasonable, hopefully, decisions rather than being 18 or 21. The class of people included in the trust is closed at the moment of the client's death. So for these wills, the class is all of the client's children living at the client's death. The class also includes any issue of a predeceased child. So these are living descendants of that child. So here's just a simple example to explain that. A client has 2 children, Alex and Blake. Alex has 1 child, Claudia, and Alex dies before the client. When client dies, Blake, the other child, is still alive and age 20, and Claudia, the grandchild, is alive and 5. The trust would include Blake because he is the child and he was alive at the time of the client's death and is under 25. And then Claudia would also be included because she is the issue of the predeceased child. So furthermore, with trusts, while we don't dive into the fine details of trust administration during this training because we're only providing simple documents, here is kind of a basic outline of how the trusts for minor children created through these wills are offered in this clinic work. Remember that when we say minor in terms of these trusts, I mean anyone under the age of 25. All of the assets the client leaves, so this could be bank accounts, a house, etc., go into one pot for all of the children or the predeceased children's issue. The named trustee, who is eventually appointed by the court, manages these assets. The trustee has the discretion to distribute trust property to the children as they see fit. So this is a discretionary trust. Again, the trustee has the discretion to distribute trust property to the children as the trustee sees fit. So this is why it's so important for clients to pick a trustee that they feel is responsible and will be able to handle the money well. Once all the children reach the age of 25, the trustee then distributes the remaining trust property to the remaining children or a child. And then this slide talks about if you use option C or D, you can let the clients know that they can use the following language for their beneficiary designation, such as on a retirement account or life insurance policy. So a lot of times we get questions from clients, just, I have beneficiaries for my 401k. How do I name this trust as a beneficiary when my accountant asks me? Well, it's trust under will of, and then your client's full name. That's exactly how you would want your client to word it. All right, so that has to do with all of our wills. Next, we're going to be moving on to the healthcare power of attorney. So just a document overview for this healthcare power of attorney. This allows the client, known as the principal, to name a healthcare agent and up to 2 successor agents to make healthcare decisions on their behalf. The healthcare power of attorney becomes effective when an attending physician has determined that the client is unable to make or communicate their own healthcare decisions. If the client is unable to communicate their own healthcare decisions, the client is the one who makes their own decisions, and the healthcare agent does not supersede. It has come up in the past where clients are not sure who they want to name as their healthcare agent. Sometimes spouses are okay with naming each other, but aren't sure who they want to name as their successor. That's okay if they aren't sure. They should still complete the document, even if they are just naming each other. You can let the clients know that if they were in a car accident together, they may want to have the successor agent in the event that neither of them can make a decision. And as first responders, this could be the most important document that our client is going to make today. So key information to explain to the client for the healthcare power of attorney. This healthcare power of attorney gives the agent a broad authority. So it essentially gives the agent the full spectrum of power to make healthcare decisions. So this includes things like authorizing medical treatments, including mental health treatments, selecting medical providers, and consenting to admission in healthcare facilities. There are even a few powers that survive the principal's death. So disposition of remains, so that's something like cremation or a burial, consenting to an autopsy, donation of body or body parts to science, and donation of organs. The principal can apply limitations to these general powers, but as it's written, the document authorizes these broad powers. The document does not provide space for a principal to give highly detailed descriptions of their wishes, so advise the clients to discuss their wishes and values with the individuals they have named as their agents, especially regarding sensitive topics like the desire for a natural death and life-sustaining measures. As mentioned, the healthcare power of attorney is only effective when a physician has rendered a decision that the principal is unable to make their own decisions. Incompetence is not a permanent condition, and when the patient regains competence, the document is no longer in effect. So for example, during surgery under anesthesia, a patient is unable to communicate healthcare decisions, so a healthcare power of attorney would be effective. Say if something unexpected happens during surgery, an agent may be called upon to make decisions about treatment. But when the patient wakes up from the anesthesia, they would be then competent to make their own decisions, and the healthcare power of attorney is no longer effective. The document will no longer be effective when the principal dies or revokes the document as well. An important note is, unlike the will, divorce does not impact the healthcare power of attorney. So if a spouse is named as your healthcare agent, that is still valid after divorce. If the client divorces and they do not want their ex-spouse making their healthcare decisions, they need to revoke their old healthcare power of attorney and make a new one. In addition, a healthcare agent does not have an affirmative duty to act when they are named healthcare agent in a healthcare power of attorney. If a doctor calls them up, they can decline and without any type of legal consequence. However, if the healthcare agent chooses to exercise any of the granted powers, the agent must use due care to act in the principal's best interests and in accordance with any provisions of the document. For mental health treatment decisions, the standard is for the agent to make decisions according to how the agent believes the principal would act. The healthcare power of attorney can also include a living will provision. We actually recently incorporated a living will as its own document, so we will be going over that separately in the following slides. And then just some practice notes. The statutory form of the document defaults to having an attending or eligible physician be the one to determine a client's competence to communicate medical decisions. However, the document allows a client to name a specific physician to be the one who will make this determination. Few clients want to do this, but if they seem like they really want to do that, explain the drawbacks. So if a specific physician is named, hospital staff will have to be able to make an attempt to locate and communicate with that person before an agent can gain authority through this document. In an urgent situation, it's quicker and more flexible just to have the attending physician to make the determination of competence. So just explaining that to the client is key. And then some practice notes. The document gives multiple opportunities for clients to provide specific limitations to the agent's general authority. You can type this into the field in the app and they will generate in the document. So for instance, if the client has particular views or religious convictions about certain treatments, they can provide a limitation so that the agent cannot consent on their behalf. We recommend not listing any specific limitations except for religious objections. A common question we do get from clients, and it's worth mentioning here, if a first responder is killed in the line of duty, an autopsy is required. Because the healthcare power of attorney already includes authority relating to consent to an autopsy, some clients have chosen to add a statement about this to elaborate the authority. So you can work with your client to get the phrase, but usually we recommend, I direct my healthcare agent to cooperate with requests for an autopsy if I am killed in the line of duty. So I'll say that one more time. I direct my healthcare agent to cooperate with requests for an autopsy if I am killed in the line of duty. And now we're going to move on to the Advance Directive, which sometimes is also referred to as a living will. So document overview here, the Advance Directive gives instructions to healthcare providers to withhold or withdraw life-prolonging measures in certain situations. Please note, life-prolonging measure is a medical term. You should not counsel the client about the meaning of this term. If the client is too uncertain, he or she can decline to complete the Advance Directive at the time of his or her appointment. Drafting note, use the client's full legal name and explain that the client should also sign his or her full legal name when this document gets notarized. So key information we want to make sure is explained to the client. So the Advance Directive only applies if you are in three very specific situations. So the first one is if the client has an incurable or irreversible condition that will result in his or her death within a relatively short period of time. Two, the client becomes unconscious or his or her healthcare providers determine that to a high degree of medical certainty, he or she will never regain consciousness. And three, the client suffers from advanced dementia or any other condition which results in the substantial loss of his or her cognitive ability, and his or her healthcare providers determine that to a high degree of medical certainty that this loss is not reversible. The client should select which of these three situations he or she would want healthcare providers to withdraw or withhold life-prolonging measures. By not selecting one of the three, this has the effect of the client saying that he or she does not want his or her healthcare providers to withdraw or withhold life-prolonging measures. In other words, he or she does want life-prolonging measures in this situation. If the client is reluctant to select any of these situations, he or she may not need an Advance Directive. It's perfectly acceptable to want life-prolonging measures in all situations. An individual does not need an Advance Directive in that case. In the second section of the document, the client can direct healthcare providers to withhold life-prolonging measures. This document draws a sharp distinction between may and shall. The client can select may if they want healthcare providers to have the option to follow the Advance Directive. This basically gives the document a voluntary effect and serves as documentation of the client's wishes. Counsel the client that if they select may, it could mean that he or she received life-prolonging measures even in situations he or she has indicated that they shall be withheld or withdrawn. The client should select shall if they want to ensure healthcare providers follow the Advance Directive. Healthcare providers would not have a choice but to follow the Advance Directive. And then following this slide, we have this section, Section 3, exceptions. This section deals with exceptions and provides a carve out for the individual to receive the life prolonging measures of artificial nutrition or artificial hydration. The client can decide if he or she wants to receive both or only one or the other. Practice note, the healthcare power of attorney also has a provision regarding artificial nutrition and hydration. Be sure that these provisions match to avoid any type of conflict within both documents. Section 6 allows the client to indicate which document should control in case there is a conflict between the Advance Directive and the healthcare power of attorney as it relates to life prolonging measures. So 2 options, follow Advance Directive or follow healthcare agent. So following the Advance Directive, the client should select this option if he or she wants to ensure the healthcare agent follows the terms of the Advance Directive. The healthcare agent would not have a choice but to follow the Advance Directive. If the client feels very strongly about not receiving life prolonging measures under any circumstances, they likely would select this option, following the healthcare agent. If the client selects this option, the healthcare agent would have the authority to override the decisions the client has made in the Advance Directive. This has the effect of making the Advance Directive documentation of what the client would want, but does not give it binding authority. Counsel the client if they select may. It could mean that he or she received life prolonging measures, even in the situations he or she has indicated they would want that to be withheld or withdrawn. Just some practice notes for the Advance Directive. Counsel the client that no matter what they have selected in their Advance Directive, his or her healthcare provider will keep them as clean, comfortable, and free of pain as possible. This is known as palliative care. The Advance Directive may be revoked at any time while competent. He or she should communicate the intent to revoke to the healthcare provider. Advise the client to destroy all copies of the Advance Directive if that is their wish. And lastly, now we're going to be talking about the power of attorney, sometimes also referred to as a financial power of attorney. And we're going to do the document overview. So simply put, the power of attorney allows the client, called the principal, to designate an agent to make decisions concerning the principal's property on their behalf. Another term for agent that you may be familiar with is attorney in fact. The statutory form uses the word agent, and it tends to be less confusing for the clients if we just say agent. The power of attorney we are doing through this program is effective as of today once the client signs it. So if we have a notary clinic tomorrow, it's going to be effective tomorrow. We do not offer any alternatives to this. We understand there are different types of power of attorneys out there, for example, a springing power of attorney, but for purposes of this program, we only use the statutory form. Remember, the documents are what they are, and they're simple documents. The statutory form is what we call durable, meaning the document is not affected by the principal's incapacity. If the principal loses capacity, the power of attorney does still stay in effect. The big key difference that is important to highlight for the client is the durable power of attorney can be used by the agent and the client simultaneously, even as the client can make decisions on their own. So, for example, if I execute a power of attorney naming my sister as my agent, my sister can make banking transactions or speak to my personal creditors on my behalf, even if I am fully capable of doing it myself. While there's nothing inherently risky about this, it highlights how awesome the powers under the power of attorney are, since they start the moment the document is signed and notarized. So now we're going to talk about specific authorities and general authorities. So the power of attorney documents grants a wide range of powers to the agent. These powers are divided into 2 groups, general authority and specific authority. The general authorities are things that people tend to think about when they are talking about financial decisions in their lives. So general authorities can pertain to real property, tangible personal property. So that's the things you can touch like a car, stocks and bonds, commodities and options, bank accounts, any other financial institutions, operations of a business, annuities and insurance. estates, trust, and any other beneficial interests, claims and litigation, personal and family maintenance, and then it even can apply to governmental programs, military service, retirement plans, and taxes. Unless the client has specific reservations about granting some of these authorities, you can advise them to grant all the authorities, even if they do not seem relevant at the moment, because it's possible it can become relevant. The specific authorities are set apart in their own section because of the potential for fraud or misuse by an agent. The specific authorities allow the agent to make a gift, create or change right of survivorship, create or change a beneficiary designation, authorize another person to exercise the authority granted under the power of attorney, waive the principal's right to be a beneficiary of a joint or survivor annuity, including a survivor benefit under a retirement plan, exercise fiduciary powers that the principal has the authority to delegate, disclaim or refuse an interest in property, including a power of appointment, and access the content of electronic communications. So there is also an option for the principal to allow the agent to exercise specific authority, even if it stands to benefit the agent. So that's a little bit confusing. So here's an example. If my agent is my sister, and I always give my sister $100 at Christmas, unless I give her the authority to benefit herself through this document, she cannot gift herself that $100 at Christmas acting as my agent. Or a more consequential example is if my sister is my agent and we jointly inherit our parents' house when they die, my sister cannot disclaim my interest in the property acting as my agent unless I have given her the authority to exercise her power of attorney powers in her own favor, because she would get a larger share of the joint inheritance if that was the case. I don't want these powers to seem nefarious, but there are reasons why clients should give them a little bit of an extra thought when they're deciding. Often the client is naming an agent that they trust outright and will often choose to grant all of these specific authorities, but going over them is important. And if you have any questions on these specific authorities, if you're not an estate planning attorney, we're going to be here available for you to answer those questions. As we've talked about, this is a durable power of attorney and is therefore effective immediately. The power of attorney remains in effect until the client dies or revokes the document. Since our clients are likely getting wills at this clinic, it isn't as important to emphasize, but it's just good to know as a practice point that power of attorneys terminate on death, so the client should not rely on powers of attorneys as a will substitute. Their agents won't be able to access accounts or talk to anyone under the POA, the power of attorney authorities, if the principal has passed away. And like the healthcare power of attorney, divorce does not revoke the authority of a spouse under a client's power of attorney. So they definitely want to get that changed. The agent does not have an affirmative duty to exercise the powers granted. However, if they do exercise a power, there is a standard of care. The agent must act in the principal's best interest and in good faith, with care, competence, and diligence. They must not create conflicts of interest that impair their ability to act for the principal. Additionally, they should keep a record of all receipts and transactions. A 2-page informational sheet about the agent's standard of care is included with the power of attorney document that we give to the client. And then practice notes, review all of the general authorities with the client. If they are comfortable with granting all of them, there is an option in the app to do so. Otherwise, the app will walk you through each of the general authorities. And then lastly, emailing the documents. So once you have completed the meeting, you will email us your documents. That information was provided in an email sent to you prior to today. In your email, please provide any notes about the clients you think may be helpful to the volunteer attorneys that are reviewing the documents, and then any recommendations, feedback that you have for the program. And lastly, the key points to take away from this training: ask questions if you're unsure. Please do not change or alter the documents. They are what they are, and have fun. This concludes the substantive portion of the training.
Okay, I'm going to go over briefly the Wills for Heroes app. So the Wills for Heroes app is a web-based document production application. It's designed to be easy to use for any attorney, even if you have little or no experience with the 4 documents. The app contains a suggested script, practice notes to you explaining key points, and fields to enter the client's information. The clients were asked to fill out a questionnaire prior to the clinic, and that questionnaire tracks with the app. Although there is not a tremendous amount of information to enter, take your time and counsel the client as they make these important decisions. The information you enter saves as you proceed forward, and there's a back button if you need to return to a section. The entire session is also saved within the app, and you can navigate back to that session if need be. At the conclusion of the interview, the documents will automatically generate and be available for you to download. Be sure to read the instructions on the last page carefully as they pertain to finalizing the documents. There's one tip I wanted to share with you all about two married clients in one session. So many of our clients are married couples. In the app, you will first complete all of spouse A's documents. When you move on to spouse B's documents, there's a question asking if a spouse's documents have already been completed in the same session. So you'll see this on the screenshot of the slide. It's right here at the bottom. By selecting yes and choosing spouse A's name, all of spouse A's appointees will become selectable in spouse B's documents. We have found that couples will often name the same handful of trusted family members to serve as agents, executors, trustees, and guardians. This function of the app is designed to reduce your need to type the same names and addresses over and over again, thereby also reducing possible entry errors. If spouse A's name doesn't appear, try opening the app in a new window. One technical note, on the list of selections from spouse A's agents, there will be a set of parentheses next to the name stating which role that name is associated with in spouse A's documents. For instance, if spouse A named Sarah Sibling as a healthcare agent, durable power of attorney agent, and executor, Sarah Sibling will have her name will appear 3 times on the list with those roles listed next to her name. If spouse B wants to name Sarah Sibling as a healthcare agent as well, it's helpful to select the Sarah Sibling from the list that aligns with that role. This is because the app pulls different data from the various documents. So if you selected Sarah Sibling with the executor role within the healthcare power of attorney, Sarah Sibling's address would not automatically fill in because no address was entered related to her appointment in spouse A's will as executor. Likewise, if you select Sarah Sibling with the healthcare agent role under executor for spouse B's will, Sarah Sibling's sex will not automatically fill in because no sex is associated with the data for healthcare agent. There's nothing wrong with selecting a different role. Nothing bad is going to happen or crash on you, but there may just be additional information that you'll have to fill into the app. This feature is optimized for your convenience if you can select a previously named appointee within the same role for autofill purposes. A few practice notes. Be sure to exchange phone numbers with the client right at the start. Then if Zoom goes down or you lose internet connection, the two of you can just connect by phone to finish the app script and interview and to complete the document production. We also ask that you be sure to take a look at the client's identification at the start of the Zoom to verify their identity. There are a number of fields in the app that are required, and the app will not advance if a value is not entered. Of course, there will be times where a client needs to go search some piece of information out, but doesn't want to hold up the progress. So in that case, you can enter a placeholder word in all caps that alerts the still needed information. For example, if the client is missing an address, type address in the space. When the final documents are prepared, the client can either go and find that info so you can edit it in the app or directly in the document, or you can send the draft document to wfh@ncbar.org with a note that an address or whatever missing piece of information is still needed, and then instruct the client to bring that information with them when they go to pick up their documents on site. That's worth noting that if there's anything else that you think we should know about the client's circumstances or documents prior to having the client sign the documents, please include that information in your email when you send us the final documents so we can make a note on their file. Okay, and finally, before concluding your call with a client, please cover instructions for the in-person notary clinic. The notary session typically takes about 30 minutes. Okay, well, that concludes our training. We can't thank you enough for volunteering to provide these essential legal services to pro bono clients. Wills for Heroes truly could not be possible without all of our amazing volunteers. So thank you so much.